Have you ever really stopped and thought about money in politics? I mean, who gets to spend what? What are the rules? It feels pretty complicated sometimes.
Oh, absolutely. It's a huge topic. And today we're diving into one of the cases that really shook things up. Citizens United v. Federal Election Commission.
Right, Citizens United, that's the 2010 case, isn't it? The one everyone still talks about when campaign finance comes up.
That's the one. It fundamentally changed the game regarding campaign finance regulations here in the U.S.
Okay, so our mission today really is to unpack Citizens United. We want to understand its core, but also see how it, fits with other big Supreme Court rulings on this stuff, find the connections.
Exactly. We're looking at the Citizens United case summary itself, obviously, but also drawing from summaries of related cases like Buckley v. Vallejo, FEC v. Wisconsin, Right to Life, McCutcheon, Randall v. Sorrell, even Williams v. Lee, trying to see the legal threads.
Okay, so Citizens United, let's start at the beginning. What led up to this? What's the factual background we need?
Well, it really starts with a law called the Bipartisan Campaign Reform Act, or BCRA. Most people probably know it as McCain-Feingold.
Ah, yes. McCain-Feingold, I remember that.
Right, and a key part of BCRA was aimed at regulating how corporations and unions could spend money during elections. Specifically, it stopped them from using their general treasury funds.
Their main company or union bank account, essentially.
Exactly. They couldn't use those funds for ads that explicitly supported or opposed a candidate within 30 days of a primary or 60 days of a general election.
So like vote for Smith or vote against Jones, ad funded directly by a corporation right before Election Day that was out under BCRA?
Precisely. The idea was to curb the direct influence of these big organizations right when voters were making up their minds. They could still fund things through their political action committees, their PACs.
Which are funded by voluntary donations, not the main corporate pot.
Correct. So that brings us to the group Citizens United. They're a nonprofit, and importantly, they get some funding from corporations. And back in 2008, they made this movie, Hillary, the movie. It was, well, pretty critical of Hillary Clinton, who was running for president then.
I remember that movie causing a bit of a stir.
It did. And Citizens United wanted to make it available through video-on-demand services, and they also wanted to run TV ads promoting the movie.
And the timing was the issue.
Exactly the issue. They wanted to do this right before the 2008 primaries, which put them smack dab in the middle of that restricted period defined by BCRA.
Uh-oh. Collision course.
You got it. The Federal Election Commission, the FEC, looked at it and said, basically, nope, this movie is designed to influence voters, it's electioneering communication, and you can't use your general funds to broadcast or advertise it this close to the election.
So the FEC applied the BCRA rules.
They did. And Citizens United's reaction was immediate. Hold on. This violates our First Amendment right to free speech.
And that's the lawsuit. They sued the FEC.
That's the core of it. They filed suit. The initial court, the district court, actually sided with the FEC, upholding the BCRA restrictions. But BCRA had this specific provision allowing for a direct appeal to the Supreme Court in cases like this. So up it went.
Okay, so now it lands at the Supreme Court. What's the central legal question they have to grapple with?
It boils down to this. Does the BCRA rule preventing corporations and unions from using their own money for independent political advertising ads, not coordinated with a campaign, violate the First Amendment's guarantee of free speech?
Independent spending. That's the key phrase here, isn't it? Not direct donations to campaigns, but spending about candidates.
Crucial distinction. We know from cases like Buckley v. Vallejo, which we'll get into, that the court often treats contributions and independent expenditures differently. This case was squarely focused on those independent expenditures.
Okay, so what were the main arguments from Citizens United? Why did they think BCRA was unconstitutional?
Well, their core argument was pretty fundamental. Spending money to get a political message out, like running ads for their movie, is a form of speech. And political speech, they argued, is absolutely essential in a democracy and deserves the highest protection under the First Amendment.
Okay, speech is speech, even if it costs money to amplify it.
Right. And they push further, saying the First Amendment doesn't just protect individuals speaking, it protects groups too. Corporations, unions, they should have speech rights just like individuals or, say, media organizations.
That's an interesting point. Like, newspapers are corporations, and they endorse candidates all the time in editorials.
Exactly. That was part of their logic. Why treat a nonprofit corporation producing a film differently from a media corporation publishing an editorial? They also framed it as an issue of censorship. If the government can ban this movie close to an election, what's next? Books.
A slippery slope argument.
They argued against giving the government that kind of power to decide who gets to speak about politics and when.
What about the classic concern that big corporations just have so much more money that their speech could drown out everyone else?
They addressed that. Their view was, essentially, the First Amendment doesn't guarantee equal speaking power. Just because some can speak louder because they have more resources doesn't justify making their speech illegal. The answer isn't censorship, it's more speech.
Okay.
And critically, they kept coming back to the idea that independent expenditures don't pose the same risk of quid pro quo corruption that direct money for political favors exchange as direct contributions might. If the spending isn't coordinated with a candidate, where's the direct trade-off?
That independence piece is doing a lot of work in their argument.
It really is.
Yeah.
And one last point they made was kind of practical. These kinds of restrictions, they argued, often end up benefiting incumbents, the people already in office. Incumbents usually have more name recognition, easier media access,
Sure.
and limiting outside spending makes it harder for challengers and independent groups to, get their message out and criticize the status quo.
Okay, so that's a pretty comprehensive case from Citizens United. What about the other side? What was the FEC's defense of the BCRA law?
The FEC came at it from a different angle. They emphasized that the First Amendment is primarily about protecting the liberties of individual citizens, we the people, right? Not necessarily artificial entities like corporations.
So a focus on individual rights versus corporate rights.
Yes. And they pointed out, look, BCRA didn't silence corporations or unions entirely. They could still speak politically through their PACs, funded by those voluntary contributions we mentioned. There was still an avenue.
So it wasn't a total ban, just a regulation on how they could spend certain money.
That was their argument. They also leaned heavily on precedent. The Supreme Court had previously upheld similar bans in cases like Austin v. Michigan Chamber of Commerce and McConnell v. FEC. They basically said, we've already decided this kind of regulation is okay.
Stick with what the court has said before. Makes sense.
Absolutely. Stare decisis, let the decision stand is a powerful principle. And the FEC really hammered the corruption argument. But they defined corruption more broadly than just direct bribery.
How so?
They talked about the risk of undue influence and the appearance of corruption. The idea that even if you can't prove a direct trade, allowing huge sums of corporate money to flow into election ads could make politicians beholden to those interests, or at least make the public think they are.
So it erodes public trust, even without a smoking gun bribe.
That was the concern, maintaining public confidence in the integrity of the whole process. And related to that, they brought up the drowning out point again, that the sheer volume of corporate spending could overwhelm the voices of average citizens and smaller groups, creating an unequal playing field.
Okay, so a real clash of principles here. Free speech versus anti-corruption and fairness concerns.
Yeah.
How did the Supreme Court rule?
It was a close one, 5-4. The majority sided with Citizens United.
Wow. So they struck down that part of DCRA?
That they did. The court ruled that the First Amendment prohibits the government from restricting independent political expenditures by corporations and unions. And in doing so, they explicitly overturned parts of those prior cases, Austin and McConnell.
Overturning precedent, that's a big deal in the legal world. What was the core reasoning of the majority?
Justice Kennedy wrote the opinion. It really rested on two main ideas. First, a strong declaration that corporations, like individuals, have First Amendment free speech rights. Second, that political speech is absolutely vital to democracy, and the identity of the speaker, whether it's a person or a corporation, doesn't change that fundamental value.
So corporate political speech is protected speech, period.
That was the message. They acknowledged the government's interest in preventing quid pro quo corruption.
That direct exchange.
Right. And they said, okay, maybe limits on direct contributions to candidates are justifiable for that reason. But independent expenditures are different. Because they aren't coordinated with the campaign, the risk of that direct quid pro quo is much lower, or at least not compelling enough to justify restricting the speech itself.
So the court drew a really bright line between contributions and independent spending in terms of the corruption risk.
A very bright line. That distinction is absolutely central to the Citizens United ruling. It's worth noting, though, they did not strike down the disclosure requirements in BCRA.
Ah, okay. So corporations could spend independently, but we could still see who was paying for the ads.
Generally, yes. The transparency aspect remained, at least in theory. The ruling was about the spending limit, not the disclosure.
Got it. Now, the 5-4 vote means there was a strong dissent. What were the main arguments from the 4 justices who disagreed?
Presta Stevens wrote the main dissent, and they pushed back hard. Their fundamental point was that the First Amendment was written to protect people, natural persons, not artificial entities like corporations, which have state-granted advantages.
So back to that core distinction between individuals and corporations.
Exactly. They argued the government should be allowed to regulate corporate money and politics, precisely because corporations aren't people and have amassed wealth through legal privileges. They worried that unlimited corporate spending would, in fact, distort the marketplace of ideas and drown out individual voices.
The very concerns the FEC raised.
Yes. The dissenters strongly urged the court to stick with the precedent set in Austin, which had allowed restrictions on corporate independent expenditures. They felt the majority was unwisely discarding years of legislative efforts and judicial precedent aimed at limiting corporate influence in elections.
They saw it as a dangerous departure.
They did. They also pointed out, like the FEC, that corporations still had the pass-C route available for political expression, and they raised an interesting point about protecting shareholders.
Right, you mentioned that earlier. How does that work?
The idea is that corporate executives might use shareholder money, the company's general funds, to support political causes or candidates that the individual shareholders might actually oppose. So restricting that spending could be seen as protecting shareholders from having their investments used for political speech they don't agree with.
That's a fascinating angle. So the dissent saw BCRA's rules as a reasonable way to protect election integrity and even shareholder interests.
Pretty much. They saw the majority's decision as opening the floodgates to corporate influence in a way that undermined democratic principles.
And the impact. Well, it seems undeniable, right? The rise of the super PACs.
Oh, absolutely. Almost immediately after the ruling, we saw the creation and explosion of these independent expenditure-only committees, super PACs. They can take unlimited amounts of money from corporations, unions, individuals,
Unlimited sums.
unlimited sums, and spend it to explicitly advocate for or against candidates, just as long as they don't officially coordinate with the campaign, which itself is a fuzzy line sometimes.
And we've seen billions spent through these groups since then.
Billions. Every election cycle seems to break new records for outside spending. It has definitely changed the financial dynamics of campaigns.
Okay, so that's the deep dive into Citizens United itself. Now let's connect it back, as we planned, to those other key cases. You mentioned Citizens United didn't come out of nowhere. How did a case like Buckley v. Vallejo from 1976 lay the groundwork? What's the connection there in terms of reasoning?
Buckley is really the foundational case. It's where the court first firmly established the principle that spending money in elections is a form of speech protected by the First Amendment. That whole money is speech idea really takes root there.
Okay, so Buckley says spending equals speech.
Right. But Buckley also made that crucial distinction we keep talking about between contributions to candidates and independent expenditures about candidates. The Buckley court said, yes, you can limit contributions to prevent quid pro quo corruption. But independent expenditures, those get much stronger First Amendment protection because they're seen as pure speech, less likely to corrupt.
Ah, so Buckley drew the same line Citizens United later emphasized.
Exactly. The reasoning in Citizens United that independent spending by corporations deserves strong protection because it's speech and the risk of quid pro quo corruption is lower flows directly from the framework established in Buckley. Buckley said independent spending gets more protection. Citizens United essentially extended that strong protection to corporations and unions doing that independent spending.
So the logic regarding independent expenditures is really similar, just applied to a different type of spender in Citizens United.
That's a great way to put it. Buckley set the precedent that independent spending is highly protected speech, and Citizens United relied heavily on that precedent.
Okay, now what about Austin v. Michigan Chamber of Commerce? You mentioned Citizens United overturned parts of Austin, so that's a direct conflict, right?
A direct conflict, yes. Austin, back in 1990, actually upheld a state law restricting independent expenditures by corporations in state elections.
So Austin said it was okay to limit corporate independent spending.
It did. The rationale in Austin was based on preventing a different kind of corruption, not quid pro quo, but what the court called the corrosive and distorting effects of immense aggregations of wealth accumulated with the help of the corporate form. Basically, the idea that corporations, due to their legal advantages, could unfairly dominate political debate.
So Austin accepted an anti-distortion rationale for limiting corporate speech.
Correct. And Citizens United explicitly rejected that rationale. The Citizens United majority said that anti-distortion interest was not a valid reason to restrict political speech. They essentially said you can't suppress speech just because the speaker is a corporation or has a lot of money. So Citizens United directly overruled Austin on this key point, significantly changing the landscape by removing that anti-distortion justification.
That really highlights how Citizens United marked a major shift in the court's thinking on corporate speech.
A huge shift. It narrowed the permissible reasons for regulating corporate political spending.
Let's talk about FEC v. Wisconsin Right to Life from 2007. How does that fit in? It dealt with issue ads, right?
Yes. WRTL focused on ads that discussed issues, mentioned candidates, but didn't explicitly say vote for or vote against. BCRA had tried to regulate these too, close to elections.
And the court said?
The court said BCRA's ban on these kinds of issue ads, when they weren't the functional equivalent of express advocacy, was unconstitutional. They emphasized that organizations have a right to speak about issues even if candidates are involved, as long as it's not a clear call to vote one way or the other.
How does that connect to Citizens United? It seems like a similar theme of protecting speech around election time.
Exactly. Both cases show the court pushing back against broad restrictions on speech related to elections. WRTL protected issue advocacy that wasn't explicit electioneering, say you can't ban speech just because it might influence an election. Citizens United went further, protecting even explicit independent advocacy funded by corporations. So there's a shared thread, a reluctance to let the government broadly censor political speech, whether it's issue-focused or candidate-focused, especially when it's done independently.
So both cases kind of carve out more space for organizations to speak during campaign season.
Precisely. They both reflect a view that favors robust, even sometimes critical, discussion around elections.
Okay, shifting gears slightly to McCutcheon v. FEC from 2014. This one was about individual donation limits, specifically aggregate limits.
Right. Not how much you could give to one candidate, but the total amount one person could give across all candidates and committees combined.
And the court struck those down. What was the reasoning, and how does it echo Citizens United?
The court, particularly the plurality opinion, struck down those aggregate limits. And the key reasoning, they reiterated that the only acceptable government interest strong enough to justify limiting contributions is preventing actual or apparent quid pro quo corruption.
There's that phrase again. Direct exchange.
Exactly. They explicitly rejected the idea that limiting contributions just to reduce general influence or promote equality was a valid reason under the First Amendment. Concerns about donors having access or ingratiation weren't enough. It had to be about preventing that direct trade.
And that sounds very similar to the Citizens United reasoning about independent expenditures.
Very similar. Both cases significantly narrowed the definition of corruption that could justify campaign finance regulations. Citizens United said independent spending doesn't pose a quid pro quo risk, so it can't be banned. McCutcheon said aggregate contribution limits weren't closely tied enough to preventing quid pro quo corruption, so they had to go too. Both really zeroed in on quid pro quo as the main, perhaps only permissible target.
So a consistent theme across both cases. Unless you're preventing direct bribery or its appearance, tread very carefully when restricting political money.
That's the core message coming through, a stricter test for justifying these kinds of regulations.
What about Randall v. Sorrell from 2006? That involved Vermont's state-level limits.
Yes, Randall dealt with Vermont's very low limits on both campaign expenditures and campaign contributions.
And the court struck down both.
They did. They struck down the expenditure limits based on the Buckley precedent that you generally can't limit how much candidates spend. And they also struck down Vermont's contribution limits, finding they were just too low.
Too low? How does that work?
The court said the limits were so restrictive, they severely hampered the ability of candidates, especially challengers, to raise enough money to campaign effectively. They argued the limits weren't closely drawn to the goal of preventing corruption and actually burdened First Amendment rights, the right to associate, to speak, to fund campaigns too heavily.
So even contribution limits, which Buckley allowed, can be unconstitutional if they're excessively low and restrictive.
That's what Randall established. And the connection to Citizens United and McCutcheon is this general skepticism towards overly broad or severe campaign finance restrictions. Whether it's banning independent expenditures, Citizens United, setting aggregate limits, McCutcheon, or setting contribution limits extremely low, Randall. The court showed a pattern of viewing these regulations as potentially significant burdens on political speech and association that need strong justification, usually tied back to that narrow quid pro quo concern.
A pattern of protecting the flow of money for political communication, unless the limits are very carefully tailored.
You could definitely see it that way.
Okay, one more case to connect. Williams U. Levy, the Florida Bar from 2015. This one seems a bit different. It upheld a restriction, right?
It did, which makes it an interesting contrast. This case involved a Florida rule that stopped candidates running for judicial office from personally soliciting campaign funds.
So judges or people running for judge couldn't directly ask for money themselves.
Right, their campaign committees could, but the candidates themselves couldn't make the personal ask. And the court upheld this rule 5-4 again, interestingly.
Why uphold that restriction when they struck down so many others?
The court drew a distinction. They emphasized the state's compelling interest in preserving public confidence in the impartiality and integrity of the judiciary. The appearance of judges personally hitting people up for cash could really undermine that confidence, they reasoned.
Ah, so the unique nature of the judiciary made the difference.
Exactly. They said maintaining judicial integrity was a strong enough reason to justify this specific narrow restriction on speech, that personal solicitation, even under strict scrutiny. This contrasts with Citizens United, where the court didn't find the general anti-corruption, anti-distortion arguments compelling enough to restrict corporate independent speech in regular political elections.
So Williams v. Lee shows that the First Amendment analysis isn't always identical across all contexts. Sometimes specific government interests can justify restrictions.
Precisely. It shows the analysis is nuanced. While the trend in cases like Citizens United, McCutcheon, and Randall was towards deregulation based on a narrow view of corruption, Williams v. Lee reminds us that other compelling state interests, like judicial impartiality, can sometimes tip the balance the other way for specific types of speech restrictions. It highlights the edges of the doctrine.
That's a really helpful comparison. It clarifies the main thrust while acknowledging the exceptions. Okay, let's try to pull this all together. What's the big takeaway from Citizens United and its place in this line of cases?
Well, the key takeaway from Citizens United itself is that it dramatically expanded the ability of corporations and unions to spend money independently to influence elections. The core legal reason was the majority's view that this spending is protected political speech under the First Amendment, and the government's interest in preventing corruption wasn't strong enough to justify banning it, especially since it was independent spending, not direct contributions.
And it built directly on Buckley's foundation of money as speech and heightened protection for independent expenditures.
Absolutely. It took that Buckley framework and applied it forcefully to corporations and unions.
But it also represented a major break from Austin, explicitly rejecting the idea that the government could limit corporate spending just because of concerns about corporate power distorting the debate.
Yes, a definite departure there. Overruling Austin was significant.
And its focus on that narrow quid pro definition of corruption. We saw that echoed later in McCutcheon regarding individual aggregate limits.
That's a really strong through line.
Yeah.
Both cases reflect a court defining corruption narrowly and using that definition to strike down campaign finance regulations.
Of course, Citizens United remains incredibly controversial. The debate about its impact on who has influence, the sheer amount of money in politics, that hasn't gone away.
Not at all. It's still one of the most hotly debated Supreme Court decisions in recent memory, with ongoing discussions about its real-world effects on elections and democracy.
So maybe a final thought for our listeners to chew on. Considering this evolution of campaign finance law, from Buckley through Citizens United and cases like McCutcheon, all wrestling with speech versus corruption, what does this trajectory imply for the future? How does this legal framework shape who gets heard, how loudly they can speak, and ultimately what kind of political discourse we have in our democracy?
That's the big question, isn't it? How this balance between protecting speech, as the court has defined it, and regulating potential influence plays out is something that continues to shape our political reality. Definitely something to keep thinking about.